So this case involves a parking space. In Switzerland, you have to pay for parking space. They're usually anywhere from 90 francs per month to 150 per month. The one that I acquired in 2019 was 115 plus tax. So in the end, I had to pay like 120 per month. I signed a contract, and this is where the case gets highlighted, the signing of the contract. So upon signing of the contract reads as follows. The lease begins on May 1st, 2019 and lasts until April 30th, 2020. That is the minimum duration of the contract. The lease continued to read in the same section that if the termination is not made, the tenancy will continue indefinitely. If you do not terminate the contract within the minimum scope, which is the year, then the contract is deemed a permanent contract. You don't have to sign a new contract. You don't have to contact the landlord or anything. If it's not terminated, it continues on as if it's a forever contract. And the last thing that the contract says, notice period, 3 months to the end of each month except December 31st. That is pretty clear cut. In Switzerland, if you rent anything, a house, an office space, as long as the contract becomes a permanent contract, you have to give 3 months notice. As clear as that is, there's also a law that oversees those 3 stipulated rules of a rental contract. And the law here in Switzerland is Article 266. Article 266 reads, where the parties have expressly or tacitly agreed to a limited duration, the lease comes to an end on expiry, therefore without any need for notice to be given. What that means is what it says. If there is a minimum period to a contract, it means that you could actually use the minimum period without giving any notice. So, like the first part of the contract says, there's a minimum period. And the second part of the contract says, if you have not terminated the contract, then it's considered a permanent contract. The law pretty much reflects on the same. But the law highlights the powers of the first 12 months in this particular case. So in this particular case, the minimum period was 12 months. So you do not have to give a notice because the contract specifies a minimum period. The law continues to say, if the lease tacitly continues, the duration becomes indefinite. That is clear cut. In this particular case, I ended the contract on the very last day. And that's when this case became problematic. Because the landlord says, according to the contract, I am obligated to give 3 months notice. Therefore, I owe 3 months rent. I disagreed and I objected. And because of that, this matter went to court. Interestingly, after the matter went to court, my defense was very simple. My defense was Article 266 of the obligatory rent here in Switzerland. The first court, the lower court here in Zurich, came to a judgment in favor of the person that was suing me for 371. And the argument of the judge was simply, the person says, you owe 3 months, so you should pay for 3 months. That would be fair if I didn't have a legal contest, if I didn't have a challenge to that argument. That would be a very fair judgment. But my argument was Article 266, which says if there is a minimum period agreed on the contract and the minimum period is satisfied and not overrun, then no notice is required. Therefore, the person, me, could not owe 3 months rent. Interestingly, in the judgment of the lower courts, my defense was obsolete. It was not mentioned. it was as if me, the defendant, did not have any objection or any say. Again, if that was a fact, I agree with the judge's judgment. But the fact is, I did have an objection, which was not mentioned in the judge's judgment. So I did what most people would have done in a situation like that. I appealed it, and it went to the High Court in Zurich. And the appeal court ruled in favor of the lower court. The credit that I'm going to give the appeals court is that the appeal court says in an appellate procedure, you cannot use the argument as a continuation of the last court's decision. You have to find legal flaws that was wrong with the last court's decision. My argument of Article 266 was not mentioned in the lower court's judgment. Therefore, if I should bring up Article 266 now with the higher court, they're seeing it as if I'm trying to continue the argument from the lower court. So in my opinion, the lower court's judge passed a fast one by ignoring my argument and not putting it in her judgment. Furthermore, the lower court was awarding this person 60 francs as compensation. The higher court knocked the compensation ruling out of the box. They disagreed with the compensation. They believe I should pay the 370 plus the court costs, plus their court costs. I want legal minds to share their opinion. But at the same time, you don't have to be a lawyer or a practitioner of law to understand this case. It's a civil case. Rules are set in stones. And if you abide by rules, then you usually win. In this case, I believe that I followed the rules, but for some reason, the courts, can't say the high court, the lower court, interpreted wrong. As a practitioner of law, I have a philosophy that you can never lose in law if you're passionate about law. And what I mean by that is, if you lose a case, there's usually a reason why you lose a case. And you usually can learn from the reason because the court usually outline the reasons why they're going against you. So if I lose the case by judgment, I usually gain knowledge. But in this case, I've lost the case and I've gained no knowledge. So I'm none the wiser as to how or why I lost this case, because the judge in this matter did not quote a law to says, well, you're losing this case because you did this wrong, or you did that wrong, or you did this wrong. I must say in this particular case, the judge of the lower court was biased by exempting my defense argument of Article 266, showed prejudice. Should I take it to the federal court? Well, I got 30 days to decide.